Segregation had been not just custom but law in America for generations. Separate but equal had been blessed by the Supreme Court back in 1896 in Plessy v. Ferguson. Whites and blacks traveled in separate railroad cars, drank at separate fountains, ate in separate restaurants, attended separate churches, and were buried in separate graveyards. Still, times were changing, and the NAACP lawyers figured they might be able to push the court to change along with them. It was a long shot, but better than waiting on Congress.
The South was not a democracy in the 1950s. Only something like 20% of African Americans were registered to vote in the South. White Democrats in the Senate could filibuster to death any civil rights legislation. That was a pattern all the way from the 1920s to the 1950s. One of the profound ironies of 20th century civil rights history is that the Supreme Court was arguably more Democratic than Congress and the presidency.
By the early 50s, segregation was frayed by the war and torn in spots where the court had acted. The white primary was outlawed. Housing covenants outlawed. Some graduate and law schools were forced to admit blacks. But the court was aware that the big fight was still to come. The schools, K through 12, white children and black in the same classroom.
Southerners assumed that if grade school kids were in a desegregated setting, they'd get to know each other and they'd get to date each other and then they'd marry each other. And that was the strongest taboo that the South held.
Led by Thurgood Marshall and other young lawyers like Robert Carter, the NAACP Legal Defense Fund was running or aiding cases all over the country. The court picked 5 and consolidated them into one set of arguments, forever known as Brown v. Board of Education of Topeka, Kansas. As oral arguments approached, people camped outside the building to assure themselves a seat in the courtroom. NAACP lawyers Marshall and Carter were up against a formidable adversary, John W. Davis, a former presidential candidate making the last of his 140 appearances at the Supreme Court. But his arguments had a familiar ring. Separate wasn't necessarily unequal. Blacks should be happy with the way things were. Didn't states have the right to educate their children as they saw fit? When the 3 days of arguments were over, Davis was heard to remark, "I think we've got it won, 5-4, or maybe 6-3. He figured he had the Chief Justice, Fred Vinson, and his fellow Kentuckian Justice Stanley Reed. The only justices he would give up on for sure were Hugo Black and Bill Douglas. Still, at the conference after the hearing, the justices never got to a vote. It was clear there was doubt and disagreement.
Justice Douglas, in a private memo, said that when the case was first argued, there were only 4 votes to strike down segregation, and there were 5 justices who were not yet prepared to do that. Many of the justices thought segregation was profoundly wrong as a personal matter, as a moral matter. They thought segregation was Hitler's creed. That's how Justice Black once referred to it. But they weren't sure that the law condemned segregation. Precedent was strongly on the side of segregation. Custom had sanctified segregation.
And who was going to enforce it? Congress couldn't do anything about it. Could the president do it alone? Not if the president's Dwight David Eisenhower, who was decidedly lukewarm on overturning separate but equal.
The justices scheduled another hearing on the case. But before that could happen, Chief Justice Vincent died of a heart attack. President Eisenhower chose to nominate Earl Warren, formerly the governor of California. Actually, Ike didn't have any choice. He'd promised Warren the next Supreme Court slot in a deal at the 1952 Republican Convention. It turned out Ike had to make Warren the chief.
There is no reason to believe that Earl Warren is going to be the catalyst for great change constitutionally. He is involved in the Japanese-American relocation. Hell, he's an Eisenhower appointee. This is not somebody who you would look to think the world can change.
The new chief was welcomed by the other great politician on that court. When Warren was new in town, Hugo Black would take him home, open a bottle of scotch, and put some good steaks on the grill. They'd talk about the court all night. Warren asked Black to run the court conferences until he got his feet on the ground. When Warren finally took over the conference, he ran smack into Brown versus Board. None of the justices knew what to expect from the new chief.
It's an interesting way to walk into your job. What he does in this first conference in December of '53 is state the issue as a moral issue. If we uphold Plessy, we're saying that blacks are inferior to whites. Doesn't talk about the legalities of it. Then he just lets it sit.
The issue now was different from the issue the year before when nobody knew what the outcome would be. Now all the justices knew what the outcome would be. The question was what the vote would be.
Warren had to have unanimity. He couldn't expect much help from the White House, and none from Congress. Could the court take on segregation alone? The South would rebel. What army could the court send? And any dissent would become the new anthem, no, the new legal brief, for segregation in the South evermore.
The next conference on this is in January. In between, he does what Earl Warren does. He walks halls, he talks to justices, he arranges lunches. I mean, this is the way politicians approach things, and Warren was at core a politician.
He kept them talking week after week and managed to get the court to where it was 8-1, with Stanley Reed being the dissenter. He then went into Reed's office and stated, "Stan, you're in this alone now. You've got to do what's best for the country."
On May 17, 1954, there were signs. Some of the justices' wives showed up. Some clerks were tipped off. Then reporters rushed the courtroom.
Warren starts off in a bland manner, and you can't tell for a while as he's delivering the opinion what the outcome is going to be. And then he comes to the key line and he says, "And we unanimously hold that separate but equal has no place in the Constitution." And it was just electric in the courtroom when he said unanimous.
We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we unanimously hold that the plaintiffs are deprived of the equal protection of the laws guaranteed by the 14th Amendment. Plessy v. Ferguson in education is no more, and in practice, Plessy v. Ferguson itself is no more. The era of Jim Crow, constitutionally speaking, is over.
This was precisely what we urged them, almost in that language. So it was gratifying to have the opinion come down almost in the language of the argument that we made to them.
In 1951, I'd used a plain geometry book that had been used by a white student in 1935. Brown said that that was over. The hand-me-down tubas that I played in the high school band from the white high schools, it said to me that that was ended. And it said to me that at some point, I would not have to travel from Atlanta to Greencastle in Indiana to get an undergraduate degree. That my family, my cousins, my neighbors could go to Georgia Tech and to the University of Georgia. The Supreme Court decision of 1954 was for me the Magna Carta. It was the second emancipation. It was a great moment.
What I did believe was that it would end segregation and discrimination in the country. And what I also believed was that it would provide equality for black people. What I didn't realize, and this comes with experience, is that segregation was a symptom of a larger evil in the society, which is white supremacy.
Black went to a dinner a couple of days later, and all the guests said, "Oh, this is wonderful. Oh, marvelous." And Black said, "Yes, it's wonderful, but people are going to die." He had seen at firsthand in the Klan and otherwise in Alabama how raw emotions were and how close to the surface they were. And he said that the tree of liberalism will have to grow with people's blood.
For years after the case, when Black went home to Alabama, he wore a bulletproof vest. Then he stopped going altogether. He was the most reviled native son. In 1959, the state Senate resolved that Black's remains must never be buried in Alabama's sacred soil. By that time, Black's best friends had cut him off. His son, Hugo Jr., had to leave Alabama. He was getting telephone death threats. A crowd tried to burn him an effigy on his front lawn. Meanwhile, schools in Alabama hadn't changed a whit. The decision in Brown had said only that segregation was unconstitutional. A full year and another round of arguments had passed before the court decided how to make its great pronouncement a reality.